Hello, so good afternoon, class. For this afternoon, you'll have to bear with me because currently there's no electricity in our house. I don't know if this is a blackout, so I will not be able to turn on my camera. However, as much as I can, I will discuss the salient provisions of the Philippine Bill of Rights, and we will try to finish the 22 sections for this afternoon so that in our next meeting, we will be able to discuss several cases in relation to the Philippine Bill of Rights. But for the meantime, we will focus our discussion on the provisions. Although we've already discussed some provisions of the Philippine Bill of Rights. I've even presented you with several cases, of course, in the case of Cogaed, Zulueta versus Zulueta. So those are examples of cases dealing with the rights of persons pertaining to the Bill of Rights. Okay, because the Bill of Rights is one of the basic laws, no, of our country to which our human rights emanate from. Being the highest form of law, the constitutional law, it is the fundamental laws of the land. Okay, it is the most important law of the Philippines, and the Bill of Rights is very crucial in exercising our human rights. Okay, so let's first finish discussing the provisions, and next meeting I will be presenting you with several cases in relation to these rights enshrined under the Philippine Bill of Rights. Okay, so for today, you'll have to bear with me. As I mentioned earlier, I cannot turn on my video as currently we have no electricity and I'm just using my data to create this video. But hopefully you will be able to grasp the important information in relation to our discussion. Okay. So we've already discussed part of the Philippine Bill of Rights. Again, going back, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. So the first section actually discusses, of course, equal protection of the laws as well as due process of law. Okay? So by now I know that you already know what due process means, right? So I've reiterated that several times. Due process is where it hears before it condemns, proceeds upon inquiry, and only renders judgment after trial. So no person can be deprived of his life, liberty, or property without being afforded the opportunity to present himself and defend himself in court. Likewise, every person should be seen under the law as equal. Okay, so no matter how rich you are, no matter how poor you are, under the law, you have the same equal protection or the same rights. Okay. Number two, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. So prior to this discussion, I've already discussed to you cases wherein law enforcement officers and agencies can actually effect uh, warrantless searches and seizures. But it's not that easy. There are requirements to be followed. Otherwise, um, evidence improperly obtained will now fall under paragraph 2 of section 3, wherein any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. So it will be inadmissible in court and cannot be used in court as an evidence. Okay. Section 3, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So our privacy of communication is again what inviolable, and it no person could encroach upon such rights unless there is a lawful order of the court or when public safety so requires or as prescribed by law. So if you can still remember the case of Zulweta versus Zulweta, 'di ba? Because there were communications found under the drawer, but then these communications were or pieces of evidence were obtained unlawfully, then they were not recognized by the law as a valid proof or evidence. So again, they become inadmissible in court. So that's just a review because we've already discussed this provision several times. I've even presented you with several cases on this one. So I hope that you will not forget those very important concepts. Now we move on to section 4. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people to peaceably to assemble and petition the government for redress of grievances. So in our discussion soon, we will discuss this thoroughly using quizzes. But for everyone's information, most of the time, cities, municipalities will have freedom parks. No, and in those freedom parks, people can actually exercise the right to peaceably assemble. So, ito tinatawag na mga rally. That's why rallies are still allowed because honestly, it's the right of every person to redress the government of their grievances. And of course, freedom of speech, of expression, or of the press, although it is also a right, no, it is a right to express ourselves. However, these rights are not absolute. These are also limited by law. So you have the freedom of speech. You can express whatever you want. But then again, you cannot utter or create pieces or write pieces which are libelous, pornographic. So this freedom of speech or of expression, although it is protected by our Bill of Rights. Nonetheless, it is not excuse for us to malign a person, an institution, an agency, or to utter libelous statements against another. So these rights are always not absolute. They are of course tempered and of course limited, of course, by the rights of the persons at the receiving end as well. Because if we write libelous statements, and a person shall suffer because of such libelous statement, we can still be held liable for that. We can even we still even we still have oral defamation, slander, libel, and even if it's pag gumamit kita hin computer machine, no, nag-post kita online, then pwede gihapon kita, we can be held liable for cybercrime law. So the freedom of speech, of expression, or of the press, it's not absolute. So I will be presenting you with cases on this one. So I hope that you will anticipate that. We will be discussing several cases next week. But for now, we have to keep ourselves abreast of all the rights enshrined in the Philippine Bill of Rights. Okay? Now let's go to section 5. No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil and political rights. So this is actually emanates from the separation of the church and the state. So take note of this. You cannot be compelled to join any religion. You cannot be prohibited from joining any religion as well. However, the free exercise and enjoyment of religious profession and worship is also not absolute. No, so the exercise of such rights or religious rights or worship is also of course limited according to our law. So you should not practice any acts which are actually prohibited by law, against morals, conduct, and public policy and public order. Kasi if the religion, for example, promotes suicide, no mass suicide, then it's also against the law. The government will still of course have to prohibit such acts. Or if the religion also um promotes pornography, promotes oppression, or promotes the abuse of children, then of course it's not going to be those acts will not be protected by the law, because any exercise, any act should always be not against the law, not against public order, public policy, morals, and good customs. Okay? But then again, no religious test shall be required for the exercise of civil and political rights. So for example, if you want to vote, then you cannot be required to join any religion just to be able to vote. Even if you are an atheist, an agnostic, or you don't have a religion, or you don't believe in any higher being, you can still exercise these civil and political rights now, despite not belonging to any type of religion. Okay. Section 6, the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health as may be provided by law. So you can actually change your residence whenever you want to. No, except of course if you committed a crime and you have to be submitted so, or you have to be given with the penalty of imprisonment. But if you are a free person, you can establish your abode or your residence or domicile wherever you want to. Likewise, you can travel wherever you want to. However, if the such travel of such person is a threat to national security, public safety, or public health, then though our right to travel can be limited. So if you can still remember, during the surge of the pandemic of COVID-19, there were so many quarantine control points because there was a state of public health emergency. That's why the government was able to allow to do that. But on normal occasions, the government cannot restrict your right to travel. Okay? So, we will discuss this more thoroughly when we read the case of Marcos versus Manglapus. Okay, Section 7. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as the government research data used as basis for policy development, shall be afforded to the citizens, subject to such limitations as may be provided by law. So, we actually have the right to access to information. So of course you can go to the House of Representatives in their archives if you want to know more the basis on how our laws are promulgated. Then you can do that. They have an office there, which is the archives. But of course this can also be limited. There are certain limitations, especially if the information is confidential confidential, and can become a threat to national security. So, of course, kung may the mga threats to national security, this information can be considered as confidential. Bangin diriya pwede ipakita atin. But the general rule is that every person has the right to information on matters of public concern. That's why government agencies, we have the thing called transparency seal, because we have to be transparent on transactions involving government funds. So that's why, for example, DPWH, 'di ba, makikita niyo every time there's a project, you will see there, no, who is the contractor, how much is the project, when did the project begin, and when should it end. So those are types of information that should be made readily available to the public, because it is our right, part of our right in our Bill of Rights, to have access to information on matters of public concern. Okay? Section 8, the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law, shall not be abridged. So, both private sector and government sector workers can actually form unions, no, so that we can lobby for better social welfare benefits, or better benefits for every employee. I myself, I am an officer of our union in the Employees Compensation Commission. I am a director, part of the board of directors. So that's why, even if I'm a government officer, we can form or I can join a union. I can be an officer of a union. However, the union cannot engage in any activities which are contrary to law. Section 9, private property shall not be taken for public use without just compensation. So this is the thing we called expropriation. So if you're the owner of a property, I mentioned this several times, diba, in our previous discussions. So if you're an owner of a private property and the government wants to take it, no, and use it for public use, the government cannot do so without, of course, paying first the just compensation for the value of the private property. So, diri pwede kuhaonan imo property ha imo basta-basta without first, even if it's the government who is taking the private property for public use, there should always be just compensation. Section 10, no law impairing the obligation of contracts shall be passed. So, under civil laws, no, the Civil Code of the Philippines, every party may stipulate such terms and conditions in a contract, so long as these are not contrary to law, public order, public policy, morals, and good customs. So, waray balaod nga pwede himuon, nga pwede magyakan nga, oy, sige, invalid na ito nga iyo contract. Unless otherwise, from the very beginning, the contract is already invalid. But generally, our legislation cannot say that the contracts between these parties are invalid. No? So, uh, parties can actually stipulate whatever they want in a contract, so long as these are not contrary to law, public order, policy, morals, and good customs. Okay? Section 11, free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. No, so actually, every person should have free access to courts and quasi-judicial bodies. At yun nga, 'di ba? In our Miranda doctrine, if the accused does not have a lawyer or cannot procure the services of a lawyer, he will be provided by the government with a with a lawyer, because it is the right of every person to be provided with adequate legal assistance. Okay, so that's why we have the PAO, the Philippine uh Public Attorney's Office. Okay, so take note of that. No, that is actually one right The section 11 is one right that we can actually see in our what in our Miranda doctrine. No? So if you do not have or if you cannot procure the services of a lawyer, the government will provide for you. So okay. Section 12. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of a counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. So, yun nga, this is our Miranda doctrine. But take note, these rights can be waived in writing and in the presence of counsel. But but if there was a waiver, the accused signed a waiver, but there actually was no counsel during the time of his signing of the waiver, there is no valid waiver of such right. Both must concur. Okay? There should be a signed waiver in writing, and the waiver should have been made in the presence of a counsel. Paragraph 2, no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detentions are prohibited. A person can only be detained, to take note, a person can only be detained in the proper detention facility, not everywhere. Bisan pa ito pulisit nag-detain ha iya, even if there was a valid warrant of arrest, but he was detained in 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 a detention facility not authorized by the government, then the detention is invalid, and the person who detained him in the improper detention facility can actually be charged for violation of criminal laws. Any confession or admission obtained in violation of this or section 17 hereof shall be inadmissible in evidence against him. So for example, gin-torture lahiya, no, gin-torture lahiya, siya umamin na lahiya, then it is also inadmissible in court if it is found that he was actually just tortured, forced, and violence or threat or intimidation was made just for him to admit or to confess, then the confession or admission is not valid. The law shall provide for penal and civil sanctions for violations of this section, as well as compensation to and rehabilitation of victims of torture or similar practices and their families. So that's why we have provisions of the revised penal code. Okay, so I will discuss that further when we discuss cases pertaining to these provisions. Okay. Section 13. All persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall before conviction be bailable by sufficient sureties or be released in recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. So take note, no? Take note. If the offense is punishable by reclusion perpetua and the evidence of guilt is strong, then bail is a matter of discretion of the court. But if the offense is uh punishable by penalties less than reclusion perpetua and the evidence of guilt is not strong, then bail is a matter of right. So, for example, diba, theft. So, it's a matter of right of the person or the thief to actually post bail. Okay? Section 14. No person shall be held to answer for criminal offense without due process of law. So once again, the due process of law enters here. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and the cause of the accusation against him, to have a speedy, impartial, and public trial, to meet with the witnesses face to face, and to have a compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified of his failure to and his failure to appear is unjustifiable. So, yun nga ha, in all criminal prosecutions, the accused shall always be presumed innocent until contrary is proved. It is upon the prosecution to determine that the accused is actually guilty beyond reasonable doubt. And he should also enjoy to be heard by himself and counsel. Again, he should be provided with a counsel to be informed of the nature and the cause of the accusations against him. So he should be able to know what his infractions are, so that he can validly lay down his defense as well. He should also have a speedy, impartial, and public trial, and to meet the witnesses face to face. So that's why the accused is given the chance, no, to confront the witnesses, no, during the presentation of the witnesses, and to have the compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. So the government should help him actually to secure the attendance of witnesses in his behalf. Okay? Section 15, the privilege of the writ of habeas corpus shall not be suspended, except in cases of invasion or rebellion when public safety requires it. So there should be a declaration of invasion or rebellion. That's why most of the time there's a suspension of the writ of habeas corpus when there is a declaration of a martial law. But the declaration of a martial law, the president cannot declare martial law anytime. Okay, so there should be a basis for that. There should be a valid invasion or rebellion when public safety would require the suspension of the writ of habeas corpus. Section 16, all persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. So now there are only a certain numbers to which a judge can decide a case. Okay? Otherwise, if the judge does not decide the case within the specific number of days or months, then he can also be sanctioned or administratively penalized. Section 17, no person shall be compelled to witness against himself. So, iton accused, diri pwede yaknan nga, agi kay amin nagadla, no? Diri ito pwede. No? So, he can actually say that I invoke my right against self-incrimination. No? So, that is also one of his rights. Section 18, no person shall be detained solely by reason of his political beliefs and aspirations. No involuntary servitude in any form shall exist except as a punishment for a crime whereof the party shall have been duly convicted. So kung nadiri ka pagtrabaho, no, nadiri ka pagtrabaho sa nga employer, you cannot be compelled to stay in such employment if you don't want to, because that would tantamount to involuntary servitude. If you want to resign, then you resign. The employer cannot stop you from resigning. Section 19, excessive fine shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall the death penalty be imposed unless for compelling reasons involving heinous crimes, the Congress hereafter provides for it, any death penalty already imposed shall be reduced to reclusion perpetua. So take note, currently there's a suspension of the imposition of the death penalty, so courts cannot impose death penalty. So automatically the death penalty will be reduced to reclusion perpetua. The employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. No? So again, there should be no physical, psychological, or any other abuse that uh, the detainee or the prisoner should suffer from. So substandard inadequate penal facilities under subhuman conditions shall be dealt with by law. So take note of that. Section 20, no person shall be imprisoned for debt or non-payment of poll tax. So take note, just because may utang kita, dire kita pwede mapriso. Okay? Waray na piprisuhan utang. Unless otherwise, you sign the promissory note, no, acknowledging your debt and promising to pay. The breach of the promise to pay now becomes actionable. But no person can actually be imprisoned just for the mere non-payment of debt. Asya to't iba mayakan na lang nga. Wala man napripriso utang, tinuod bang good. But then again, an utang, bisan mo rin napripriso ito, kailangan bayaran. If nakautang kita, no, di naman kita mapriso, pero aton mga properties could be made to answer for such debt. So, an aton balay, an aton sarakyan, or any other personal property belonging to us. Section 21. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. So if you kung may gin-file nga case for the same offense to, there was already filed case of theft, pero the accused was acquitted, was not guilty, considered guilty beyond reasonable doubt. But then the aggrieved party, of course, they felt that it was injustice to them, so they filed another case of theft. Can they do that? No. That will now already be uh, double jeopardy. So you cannot be put twice on jeopardy for the same offense. Makakausala. Pag na-acquit na nga ni iton accused, then that's the end of it. There's nothing more to discuss on that. Dapat tapos na ang kaso. Diri na liwat, pwede buhiun liwat utro ang kaso. Just because the aggrieved or the offended parties were not satisfied with the decision of the judge. Once the judge actually acquits an accused, then it's already final. Okay? Generally final. Section 22, no ex post facto law or bill of attainder shall be enacted. So, diba? We've discussed this several times, ex post facto law, bill of attainder. So, we've discussed this exhaustively, so I don't have to repeat this all over again. No, so take note of the 22 sections under our Philippine Bill of Rights. Okay? So these are very important rights that we should know so that we can be protected, no? So we will discuss all these rights further by giving you with several cases next week. So I will be preparing the cases for next week. We are almost finished. We will just go to the Commission on Human Rights and War Crimes, ICC, and those are the last topics that we have to discuss until your final exam. So we are almost done. We're almost done with our discussion on human rights, but I might add a few more topics, especially on on our own local laws. Okay? So anyway, that's it for today. It's just a very short discussion, but take note, we will have a short quiz after our discussion. So just answer the questions that I'm going to be posting. You have to answer by 7 p.m. Okay, so anyway, that's all for this afternoon class. Thank you so much for bearing with me. And as much as I would have wanted to meet you today, the electricity has been erratic. So I decided to just to conduct or to pre-record my presentation so that we can also focus on the discussions of our cases next meeting. And then after the discussions on the cases, we will move forward to the Commission on Human Rights, the International Criminal Court, and then war crimes. So that's it for this afternoon, everyone. Thank you so much. Please don't forget to answer the quiz, and I'll see you again on Tuesday next week. Thank you and good afternoon.